stand is different, and in the courtroom the stand is different. And that is where Lordship may kindly scrutinize his conduct, in my respect. Having said about the conduct of the accused, I will be completing within 10 minutes. Kindly see, it is submitted that the judgment in Naran Kachadia, delivered by this Honorable High Court, coordinate bench, declining to stay the conviction under 389(1), is overruled or set aside by the Honorable Supreme Court in the same proceedings which were carried out. That is not factually correct. Kindly see, if you also have seen me, Lord, I need not waste.
I have seen that.
I am obliged. Then I will not.
It
was a consent quashing for all purposes.
It was only on a ground of compromise.
Grateful. Therefore,
5 lakh rupees they have paid, therefore they have said.
Obliged. That is all that I wanted to submit. If it is present in my Lord's mind, I did not take your Lordship's precious time on that point. But therefore, the law laid down in Kachadia, I am placing into service, which is so far not overruled.
The observation made by the Honorable Court is confirmed by the Honorable Apex Court.
Is confirmed, at least if not set aside at any rate. Now, therefore, where there also a public figure was there.
Yes.
And the court said they do nothing doing. What is this? If you commit such offense, though you are acquitted from a serious offense of atrocity, I will not protect, I will suspend the sentence.
Yes.
But I will not give you license to continue because of my order.
Supreme Court order emanating.
I have annexed both the orders,
I have
pages, then I
even from their compilation it is there.
Lord, in fact, we are not raising this at all. Let me be clear.
No, Mr. Singh.
Just a minute.
I'm sorry.
What we are emphasizing there is, Lord, when the Lordship of the Supreme Court passed the order, they have said that the right of the electorate in a by-election, it is only that part.
No, in fact, Dr. Singhvi has raised these serious that Naran Kachadia judgment is already overruled by the Honorable Apex Court.
Let Lord know the time.
Yes.
That is the part, Lord. I Lord, had the occasion to submit it there. That is the part. The overruling is not in that sense. It is in this sense that when we say irreparable loss and irreparability, the Apex Court has noted in the judgment, Lord, that other part. So, if there is any impression on correction, there's no contradiction as such. The only part we are highlighting is that the electorate of the constituency, to which that particular person belongs, they also have an interest in the matter. That's the only part. So let's show that my Lord not have to bother about that. We are not relying on that in the sense that all these conditions that changed, we had apologized, he was asked to pay a fine, he had paid the fine. The only relevant part for our purpose is that.
It's fine. Yes. Since the stand was taken earlier different, therefore I submitted this. Anyway, if that is the stand, I have nothing more to say. The stand was that it is set aside virtually and not approved by the Supreme Court. I have annexed the judgment which is on judgment compilation page 12, paragraph 20 to 26 are relevant paragraphs of my Lord Justice Shukla's judgment in Naran Kachadia. Now, my Lord, kindly see, all submissions were made. All submissions were made. Each and every submission, my Lord, I am not picking up and submitting reply. But the relevant is that except reading few paragraphs from the judgment of the appellate court, I could not gather that on what grounds the judgment is being challenged. This is not the first application before the Honorable Court, High Court, under 389(1). It is already adjudicated by the competent appellate court. You are aggrieved by that order. Very well, you can file this proceeding. I am not saying anything. But then you will have to point out some infirmity, some error, factual or legal, committed by the appellate court. That is not done in my respectful submission. Once that is not done, this is not a first application coming for the first time before the High Court, and High Court has to consider. The validity of conviction also, my Lord, is not the subject matter of this proceeding. It is sub judice before the appellate court. So that will be considered. One more point about 202 is also raised, that prior lacuna is pointed out. But I am placing into service section 465 of the Criminal Procedure Code, subsection 1 and 2 both, that at the threshold, right till the conviction is recorded, you have never raised this contention before any forum, including the same court or other superior court. And therefore, trial cannot be considered as vitiated. In that line of the matter, even that, my lord, substantial compliance is already there as per the judgment of 202. Very 465, my lord. Subsection 2, my lord, kindly see more particularly. I will read only 4 lines. Nothing. 465 subsection. In determine, I'm sorry.
Yes.
In determining whether any error, omission, or irregularity in any proceeding under this code, or any error or irregularity in sanction for the prosecution as occasioned a failure of been raised at an earlier stage in the proceedings. But subsection 1 says that
Yes.
it is burdening us is on them to show that why they could not take objection at the threshold about 202. In my submission, my lord, 202 is substantially complied with. My lord. In the alternative, I am making this submission. My lord.
Yes.
So this is on that 202. Whether I am aggrieved person or not, my lord, per se I am aggrieved. You leave aside the class and 13 crore and all that. I am Purnesh Modi, and you have said all Modis why they are thief.
Yes.
I am not in filing for 13 crore, my lord. I am at least I am humiliated, insulted, and defamed. So 199, I am aggrieved person.
In persona.
In person, that submission also is not well taken in my humble submission. That I cannot file for all and daily and all that. That is not relevant. Though it must have been discussed. But for this application, at least, if I don't have Modi surname, stands on a different footing. I have placed material on record, which is considered by the trial court and the appellate court. That yes, I am Modi. I have changed my surname years back, decades back. And therefore, I am not bothering by reading that document. But otherwise, it is at page 80. New compilation, it is there. Exhibit 39, yes. That is resolution passed by the government of Gujrat.
That is in first.
That is page 39 of the additional paper. Nothing 39 is different. Which paper? Page 25, exhibit 39. I'm sorry.
Yes.
So this is a community. And I have stated in my evidence that after following due process and procedure, my name from so and so is changed to Modi. It has come. So I am an aggrieved person. That is all the endeavor is. And that contention is also not raised in any proceeding so far till the conviction is recorded. That I have no locus standi. I am not an aggrieved person. You never said so. Such contentions, assuming that they are available without admitting, then they are required to be taken at the initial, very initial stage when the complaint is filed. You could have invoked 482 or whatever as advised proceeding. That not complaint is not tenable, not maintainable. No such contention is there. Well, much emphasis was laid on moral turpitude. Moral turpitude is undefined, is not defined by any law. In 2010, volume 8, Supreme Court cases 573. Paragraph 23 and 24. I am placing it to service. Please. Moral turpitude means for Black's Law Dictionary 8th edition. Conduct that is contrary to justice, honesty, or morality in the area of legal ethics. Offences involving moral turpitude, such a fraud or breach of trust, also termed moral depravity. Moral turpitude means in general shameful, wickedness so extreme, a departure from ordinary standards of honest, good morals, justice, or ethics, as to be shocking to the moral sense of the community. And when you say that all Modis are thief, is it not? I am putting it to myself, moral turpitude. Coincidentally, the surname of the Prime Minister of this country is also Modi. What message you are going by giving by these utterances to the world, that the opposition leader of India brands his Prime Minister as thief in public rally attended by thousands of people? Is this the language? Mirror, only on the next page 581, Mirror,
Yes.
in the quoted paragraph, which is quoted from Baleshwar Singh versus District Magistrate, 5 lines. It is discloses wellness or depravity in the doing of any private and social duty which a person owes to his fellow men or to the society in general. If, therefore, individual charged with certain conduct owes a duty either to another individual or to the society in general to act in a specific manner or not to act, and he still acts contrary to it and does so knowingly, his conduct must be held to be due to wellness and depravity. It will be contrary to accepted customary rule and duty between man and man. And this is where the moral turpitude is, if at all. Prima facie. Seriousness of offense. Offense is not involving moral turpitude. It has no societal ramification at all. These were the submissions, my lord. I am with great respect submitting that it is serious. Parliament says it is serious. It is moral turpitude because of this. And therefore, such an offender cannot be considered. His application cannot be considered, I am sorry, for stay of conviction in my respectful submission, whatever be the consequences. They are not, my lord, that consequences by which something great damage is going to be caused. Yes, said that whether I am in the house or not, this is what your public stand is. Whether I am disqualified forever, I will continue this. Very well. So in my humble submission, my lord, the application deserves to be rejected, and it is without any merit. And Lordship may kindly reject the present petition itself, my lord. Yes, some written. My friend has prepared some written submissions. I will give the copy to the other side of the place in with my lord's permission. I am obliged for the patient here.
Yes, Mr. PP, what do you have to say?
Sorry.
PP.
Just in addition to what I submitted the last
Yes.
and already said necessary for seriousness of the offenses. One more aspect with regard to seriousness would be for honorable court's consideration. As who is the offender? And as to who is the offending person? Now, offender himself, as per the submission of the legislative advocate, is the legislature. Their function is to evolve law, to legislate the law, and they themselves, I mean the petitioner himself, is breaking the law. Now, that is one more element to assess the seriousness over and above what my letter suggested. In the offending class is a together offender and offending class makes the case more serious, more particularly when petitioner is placing this case before the honorable court that he is a legislature. Their function is to legislate. They are themselves are now breaking all other aspects of my legislation.
One thing I missed, if I permit,
Yes.
1 minute only.
Yes.
I'm very sorry for that. You know, the today's paper book which I have supplied, page 2, you also may kindly see. You know, after Lily Thomas judgment, you know, the bill was moved before the parliament. Reenacting subsection 4 of section 8 of the representation of people. The proposed amendment was this. Notwithstanding anything contained in subsection 1, 2, or 3, a disqualification under any of the said sections shall not, in the case of person who on the date of conviction is a member of parliament or of the state legislature or the legislature of the state, take effect if an appeal or application or revision is filed in respect of conviction and sentence within a period of 90 days from the date of the conviction, and such conviction or sentence is stayed by the court. Provided that after the date of conviction and until the date on which the conviction is set aside by the court, the member shall neither be entitled to vote nor draw salary or allowances, but may continue to take part in the proceedings of parliament and legislature of state, as the case may be. You know, this is of 2013. The party of which the petitioner is leader was in power at the relevant time. When this bill was circulated, the present applicant himself, the newspaper reports are, I am not placing them into service because they are newspaper reports. But the report says that he torn off this bill. That what is this? I want purity of parliament. That is the legislative history of this. This bill has not passed. It was not moved at all thereafter. But it was not moved because the present applicant objected to it at the relevant time. This is all that I am facing. Otherwise, it would have provided relief to him today. I am obliged.
Yes. Yes, doctor.
Or I wonder whether it's my timing which is impeccable, or my friend's timing which is impeccable. He appears to have completed just when I arrived. I'm grateful for the accommodation. I'm sorry, Melissa, I couldn't come a little earlier, but there has been no loss of time. I seem to be exactly on time. Now, Melissa, let me go one by one. And you had a system which has largely apprised me of what has been happening. Some other leftover points my learned friends here will cover in addition. Melissa, let us just step back for a minute. I'm going to make pointed points for us and rejoinder. Let's just step back. What are we today here in? What is your lordship dealing with? Your lordship is dealing with 389. So my first question to myself, is there a section called 389? Obviously there is. Second question to myself, what is that section inserted for? For what purpose? To give a suspension of a certain act, conviction, etc., etc. What is the purpose of that section? The purpose of that section is, and can only be one, sole, that in cases where the conviction has a deleterious, serious, adverse consequence, why should your lordships, in the fitness of things, if your lordship so finds, not have the power to suspend it? That clearly is the object. Question number 4 to myself. Does 389 make difference, or does it make segmentation, or does it make categorization of the kind of offenses? Answer is clearly no. 389 is not offense specific. In other words, 389 cuts across the entirety. So it is wrong to suppose that there are certain offenses which are outside the purview of 389 or beyond the pale of 389 or somehow not contemplated as suspendable convictions or suspendable sentences. That very assumption is wrong. And the last question to myself is, How is then 389 operated? Not by looking at an act 8.3, not by looking at some section. It is operated by seeing certain parameters which my Lord has laid down. My Lord means the jurisprudence has laid down. That what are extraordinary circumstances? What are serious offenses? How, when, what, for what reasons, for what criteria would you suspend and would you not suspend? So that's my point number one. Therefore, that's the first point. There is a section created clearly for suspension. The purpose and the rationale, the raison d'etre for that section is to give relief to a person accused of a certain crime so that the deleterious consequences of that crime are mitigated. And then it is not that certain things are put in a schedule under that section which are untouchable. No. And it is not, it is section neutral, it is offense neutral. That's my first point. My second point is that the courts actually have given us enough guidance as to when, how, and for what reasons will your lordship suspend. So the test is extraordinary circumstances. Now clearly there is no section which says in this act, section 2 bracket E, extraordinary circumstances are defined as so and so. That's not the way it works. Extraordinary circumstances, fortunately, your lordship has made reasonably clear in the jurisprudence and the judgments. And this is the fundamental error of the submissions of the respondents in this appeal, because they assume or think that there is an exclusionary element in 389 which is untouchable. And they take the word serious to be a self-serving phrase, that what the complainant calls serious or thinks serious is serious. So, what is that jurisprudence on extraordinary circumstances? It's a very interesting and a simple one. Shyam Narayan Pandey educates us in the negative. What Shyam Narayan Pandey, which I'll be showing in a minute, does is, it educates us in the negative. It doesn't say what is the extraordinary circumstances by which your lordship may give. It tells your lordships on a principle of exclusion as to what are the circumstances, a few of them, where your lordships would not normally give. Even there your lordships can give, but would not normally give. So it does on a principle of exclusion. And it says so by showing that certain things would not be called an extraordinary circumstance to grant a suspension. By obvious interpretation, all other cases are fit. Now there are two categorizations there. The categorization is not only on seriousness. One is what is perceived as serious, and there is law on that. The other is even if not serious, by way of length of punishment, etc., where it is moral turpitude based. Now let us kindly see the examples where it is thought that your lordships may not have extraordinary circumstances. But remember that the caveat is very clear. Even there your lordships can give, have given in any number of cases. But your lordship will be hesitant to give. And this is very, very important. What is that, Willis? There is one death sentence. I'm being very specific. This is the case law. Second, life imprisonment. Third, imprisonment above 10 years or 10 years and more. Fourth, now these are serious. These are categorizations which are long and serious. There may be some offenses which are not so serious in terms of length, but they are considered serious in terms of moral turpitude. Namely, Prevention of Corruption Act. Now, in these cases, none of these cases, not one of them says that electoral disqualification is a serious offense, unless the disqualification is for one of these, murder, death, life imprisonment. So it's extraordinary that my learned friends are laboring and applying this to a principle of defamation, which is remarkable for the reason that defamation is nowhere in this list of any case which is considered, forget granting or not granting conviction, suspension, forget granting or not granting, etc. Not one of the cases suggests that defamation is the category of either serious or it is the category of moral turpitude offenses. Then I am asking myself, on what distorted principle are you, apart from a certain amount of dislike for the person concerned, you denying this? Then just note Defamation actually on every test falls in the opposite category. It falls in the spectrum, which is the direct polar opposite. And therefore, it is most sad that it is being treated as a offense which is unpardonable, which is a serious crime. Number one. Why? Why? And not on one, something.
Charger connected.
Here, Malas, it is a very remarkable convergence cumulatively of all the tests. For example, one obvious test is it bailable? Now, how many offences does my Lord consider bailable which are serious? What is the very meaning of the word bailable, Malas? I'm asking myself.
That you have
Second-
pointed out, perhaps 26 is the offense bailable. Otherwise, all are 26 or 27 offense.
No, that is the second point. No,
Second.
my Lord is right. That is the first point is not that. First point is simply bail. Well, forget everything else. Suppose your Lordship says bailable. Bailable broadly, subject to something means that a police can grant bail. Normally, Malas, it will never be serious if he can grant bail to me. I don't have to come to a judicial level. Normally. Second, as my Lord just said, rightly, some 22 actually we have counted, 24. The legislature thought it fit to put it in a category which is less serious. There's no question of us having a, if I may call it, the word is it's a wrong word, a very interesting word, mandatory simple imprisonment only. Can't go beyond that. Third, nobody has suggested any jurisprudence that it's an anti-societal offense. It is anti-societal. Nobody. That's the third test. Fourth is it is non-cognizable. Now, Malas, how many cases does your Lordship have where all the four intersect? Your Lordship has some, not all. All four intersect. And your Lordship is told it is such a heinous, serious offense that your Lordships can't consider 389. So, Malas, without going into 10 years, without going into life imprisonment, without going into the case law, I would say the per se category of defamation, which has a convergence of these four things, per se makes it the simplest offense, Malas. And if 389 is not created to suspend that conviction, then it might as well be repealed. 389 will not find a simpler conviction to suspend than defamation, which is non-cognizable, which is simple imprisonment, which is bailable, which is anti-society, which is not anti-societal. Therefore, Malas, my learned friend's suggestion, which I am told Malas he made today also, that because it is put in 8.3 and because there is an 8.3 disqualification, therefore it is more serious. No, on the contrary, Malas, that is a ground of irreversibility, which I am now turning to, Malas. Malas, these four tests are broadly, Malas, noted in Subramaniam Swami's case. Your Lordship will note the citation which is there, Malas. It's in our compilation at
You
page
have
1.
provided this. His first compilation.
First case. Malas, para 176 notes these four characteristics.
Para?
176. Just check out. That is non. And your Lordship will note the second case, Malas, Shyam Narayan Pandey,
Yes, that
which
will
is
be
in your Lordship's compilation at page 135. In that Shyam Narayan para 6 and Subramanian Swami 176, especially Shyam Narayan, these four intersecting elements of this offense are noted. And therefore, Malas, I submit that if there is a classic offense, which is the mildest form of offense, which must lead to a 389 suspension, then Malas, it is this. The third aspect is, Malas, and that I argued at some length last time, is irreversibility. Well, actually, 389 is a simple test. Your Lordship is not deciding whether I am guilty or innocent. That the trial court will decide or the sessions court will decide. But Malas, your Lordship is doing what your Lordship does in every case, criminal or civil. Kind of a lose, as I said last time, wrong word to use in criminal law, but still it's the same thing, balance of convenience. That is this problem, is this hurt, is this prejudice irreversible? Every case, Malas, because your Lordship cannot do the final and the interim at the same go, involves a certain interim, Malas, decision and call to be taken by the learned judge. That call is based on, Malas, irreparable loss or irreversible nature of the injury. Now, Malas, before I come to a couple of cases, or mainly one case, Malas, two paras, I want to ask myself, so I've done with the first part of the simple. I'm now, Malas, on that's the nature of the offense. Now I'm asking myself, Malas, can there be something more irreversible than a disqualification which robs you of a status as a parliamentarian or an MLA? So forget this case, Malas. Ask yourself the question conceptually. As I tell you, there are two kinds of persons, let us assume, who commit the offense of defamation. I am a member of parliament, he is a non-member of parliament, both of us commit. Well, it's the member of parliament in that sense has greater irreversible prejudice in that sense than the non-member of parliament because he loses his seat. That's a point in my favor, not against me. My learned friends have completely misunderstood the point in my favor and are projecting it as a point against me. The loss occasioned to both of us is bad. Whereas he loses mental peace, he loses so many things. I lose all of that. But one additional thing I lose, that my learned friend can't invent an answer. Whereas I have already a certain portion of my last session. I have already my role as a parliamentarian in committees. Whereas parliamentarians or MLA, same thing, function both inside parliament and outside. So when parliament is session is not the only test. There are parliamentary committees, there are parliamentary papers, there are parliamentary interjections. They happen in committee meetings also outside of the session of parliament. Now, the last part of the last session he loses. Many committee meetings he loses, and the immediate next session he will lose in case he doesn't get a suspension. But that is his loss as a parliamentarian. Here again, there is an intersecting triple loss. There is a loss to him, naturally. He is there in public life to project the voice of a certain section of people. He loses that right. That's a great loss to him. And incidentally, I've had the privilege of being a chairman of many parliamentary committees. What your lordship sees in these cameras, real solid work is done in parliamentary committees. They say, parliament at work is parliament in committee. Parliament in committee is parliament at work. A far greater degree of unanimity and convergence happens in parliamentary committees than what your lordship sees on the cameras in inside the House of Parliament. In fact, there were couple of proposals and some years ago, when they've introduced cameras for parliament, that you should have cameras for committee meetings also. I personally vehemently opposed it, so many others opposed it. That whatever little good consensual work is being done, you don't want it to be lost by the glare of cameras. So a lot of work outside of parliamentary session is also lost to parliament. That's one loss. Second loss is to the people of his constituency. They have an elected representative, Mr. X. He may be good, bad, or indifferent. It's their choice. It's not my choice, it's their choice. Their choice loses its voice. Their choice loses their voice. These are not mere empty rhetoric. These are practical. In a democracy, your lordship knows we live by fictions. when a decision is taken by 700, 800 people in parliament, it need not be that everybody who is elected them agrees with it. But the fiction is that you are elected and therefore you have the right to enact a law which is deemed to be their will. They are the electorate. So in the same way, on that fiction, that entire right of that collectivity known as we the people is lost. The third loss is to the nation, because ultimately one is the collectivity across. So one is personal, one is constituency. The third is to the entire collectivity of parliamentary democracy, because parliamentary democracy is made of a collection of those constituencies. Therefore, your lordship would have to consider, can any of these be reversed? We are on reversibility, balance of convenience. I gave lordship two simple examples. Assume, now example number one is that what is already lost, we are now arguing on 2nd or something of May. So what is lost from the date till now is lost. It is I can't think of any way in which your lordship